Hello and welcome to Williams Mullen Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm one of your co-hosts, Ed White, and today I'll be joined by my co-host and partner, Amy Pruett, in our intellectual property practice group here at Williams Mullen, to discuss updates and recent cases based on name, image, and likeness rules for collegiate athletes, or NIL, as it is called. Amy, how are you doing today?
Doing wonderfully, Ed, and we just got back from the INTA conference, as you know, the International Trademark Association, where NIL has been a big topic in the picture these days, it seems, for college athletes, and especially in the wake of lifting some of the NCAA policies a couple years ago, which had previously prevented students from engaging in NIL deals.
Yeah, absolutely. This is a very interesting topic, and there's still difference of opinion on enacting and enforcing limitations on student athletes in practice. A number of states have implemented legislation to reinforce the new policies, and there are several bills still under consideration at the congressional level. For example, there's congressional action on collegiate sports legislation, which is currently a possibility. There are multiple pieces of proposed federal legislation pending, and this shows there is significant and diverging priorities on NIL. There's also athletes, employment status, and antitrust challenges, which could significantly disrupt college athletics. So pending litigation is likely going to be the greatest source of change, I think, in the NIL landscape in the short term. Thus, colleges and universities really should anticipate that they'll have more responsibilities when it comes to direct athlete compensation, including direct payments, paying into trusts, and entering directly into NIL deals. Amy, I think it'd be helpful if we could remind our listeners of the lawsuits that led to this legislation and what the interim NCAA NIL policy says. Could you talk to us a little bit about that?
Sure, Ed. As you know, some of the class action lawsuits that were filed a couple years ago involved O'Bannon versus the NCAA, as well as NCAA versus Alston. And they resulted in decisions by the Ninth Circuit and the Supreme Court, respectively, that NCAA's previous restrictions had violated antitrust regulations. In response to that U.S. Supreme Court decision, NCAA adopted an interim NIL policy in June of 2021, allowing college athletes from all three divisions to have the opportunity to benefit from their name, image, and likeness, as well, including that individuals could engage in NIL activities consistent with state laws, if there were any, use a professional services provider for those NIL activities, and should report NIL activities to their school. So this led to about 29 states so far codifying NIL into state law, along with several attempts to pass federal legislation and third-party booster collectives becoming the dominant facilitator for these NIL agreements. Additionally, some states have enacted high school NIL laws, including Alaska, Connecticut, Illinois, Maine, Maryland, New Jersey, North Carolina, and even Virginia, with specific provisions regarding the types of categories a high school student athlete can endorse. The adopted NIL legislation also coincides with the NCAA's adjudicative body announcing substantial penalties against Florida State University for violating existing bylaws through recruiting and NIL activities. In December of 2023, Charlie Baker, president of the NCAA, announced governance and compensation recommendations for student athletes. And the NCAA adopted the first name, image, and likeness legislation requiring student athletes to report certain NIL deals and create a voluntary registry for NIL service providers. So Ed, can you tell us a little bit more about Baker's recommendations in light of the previous guidance on schools' involvement in NIL deals?
Sure, happy to. The NCAA has been promulgating policies and recommendations to its constituency for the past several years. If you recall, in November 2021, the NCAA released a Q&A document, and that declared that schools could not use NIL transactions to compensate student athletes, nor could they dictate how students use their compensation. In May 2022, the NCAA released additional guidance specifying that institutional coaches and staff may not arrange a meeting between an NIL entity and a prospective student athlete, or communicate with a prospective student athlete on behalf of an NIL entity. In October 2022, the NCAA further encouraged schools to provide educational training topics on topics such as financial literacy, taxes, entrepreneurship, and social media practices to their athletes. So, what can a school do under the current NCAA policy and guidance? Well, specifically, schools are allowed to administer a marketplace that matches student athletes with NIL opportunities. They're also allowed to arrange for NIL entities and student athletes to meet on campus or in school facilities. And they're allowed to promote student athlete NIL activity on paid platforms, provided that the student athlete or the NIL entity is paying the going rate for the advertisement. So what are they not allowed to do? Well, schools are not allowed to communicate with NIL entities regarding specific student athlete requests or demands for compensation. They're also not allowed to assist proactively in the implementation of a specific student athlete's NIL activity. And they're not allowed to provide a student athlete access to equipment unless the same benefit is generally available to the institution's students. So in November 2023, Charlie Baker testified before Congress, and he recommended that Congress pass legislation to address NIL and that this legislation would confer a special status or carve out for student athletes. The legislation would allow for NCAA schools to provide enhanced benefits or direct compensation without triggering an employment relationship, and that's important. Baker also testified before the House Subcommittee on Innovation, Data, and Commerce in connection with the draft bill sponsored by Representative Gus Bilirakis of Florida. And this bill is called the Fairness, Accountability, and Integrity and Representation of College Sports Act. This bill includes language that precludes a student athlete from being considered an employee of an institution by competing in a varsity intercollegiate athletics program. And Baker argues that by maintaining the student athlete's non-employment status, this will curtail drastic cuts that the NCAA would otherwise need to cut with women's sports programs, Olympic sports, and sports that don't typically generate a high level of revenue. Importantly, Baker also argued that allowing schools to enter into NIL deals directly with student athletes will bring NIL largely within the NCAA's ambit, and it'll provide Title IX protections. Finally, Baker testified that the NCAA plans to release a uniform standard NIL contract to provide added protection and guidance for students entering into NIL deals. So there's a lot there to unpack, but Baker is a strong proponent of this legislation. Amy, despite this history, it appears that the NCAA is still being challenged for enforcing bans on NIL for recruited athletes or for requiring them to sign away NIL rights. Can you tell us more about what's going on in that realm?
Yes, so the states of Tennessee and Virginia sued the NCAA on January 31st, claiming that NCAA's policies against NIL for recruits violated antitrust laws and the state's own laws protecting NIL rights for athletes entering college, including high school athletes. The preliminary injunction that was handed down on February 23rd by a Tennessee federal judge stopped the NCAA from enforcing its interim NIL policy, its bylaws, or any other authority that prohibits student athletes from negotiating compensation for NIL with any third-party entity until a full and final decision on the merits in that action. It also prohibited the NCAA from enforcing its restitution rule, which allows it to discipline athletes and schools if potentially ineligible athletes are allowed to play while a decision is pending. Recruits are now free to pursue those NIL deals without punishment, according to that court ruling. In granting the injunction, U.S. District Court Judge Clifton L. Corker said the NCAA's rules against NIL for recruits likely violates federal antitrust law and harms student athletes. He also said the NCAA policies do irreparable harm to athletes by denying them access to a free market before deciding which institution to attend. The judge dismissed the NCAA's argument that halting enforcement of its laws would lead to chaos and disarray, saying that their argument did not outweigh the harm being done to athletes by restricting their ability to obtain NIL. The ruling also nullifies NCAA's interim NIL policies and bylaws and prevents it from disciplining athletes and institutions for violating those policies. In a separate case in the NCAA, the House similarly sought damages for withheld wages related to March Madness TV revenue that they had acquired or earned during use of athletes' NIL during March Madness a few years ago, a loss which carried an estimate of $20 billion in damages. Recently, this past May, the case was settled and NCAA itself will reportedly pay 40% of the fund. The remaining 60% will come from unpaid distributions owed to Division I member institutions such as Football Championship Subdivision, formerly known as Division I AA. Other changes from that House versus NCAA case include revamping roster composition, whereby the NCAA can reduce roster sizes but make the entire roster scholarship eligible. One notable change is the NCAA has agreed to allow the schools to pay the settlement payments to their athletes directly. This is huge. It may impact the previous golden rule in NIL policies that NCAA level payments cannot come from the school, and could also change how collectives operate and the extent of their involvement with school athletic departments. In fact, in Virginia, a new law will take effect on July 1st, expanding NIL opportunities for student athletes, making it legal for Virginia schools to directly pay student athletes for NIL deals. No other states currently allow schools to engage in NIL directly with students, so any agreements allowing a student or a school to pay a student directly could be in violation of the applicable state law and could jeopardize the student athlete's NCAA eligibility. Just recently, this June, the NCAA was again challenged by the NC State Wolfpack players for exploiting their NIL for profit. The team alleges that the NCAA coercive player agreement players stole their publicity rights and allowed NCAA to benefit from billions of March Madness revenue dollars. So, Ed, what's next in Congress in light of these recent cases and NCAA recommendations?
Yes, I'll absolutely talk a little bit about that. And I think some of it might be, promulgated things that we're not necessarily talking about during this particular podcast by that House settlement. It'll be really interesting to see how the collectives are affected by that. But currently, what's next in Congress in light of some of these cases are a few things. For one, Republican Congressman Russell Fry and Barry Moore have introduced a bill to provide federal protection for the NCAA, the college conferences, and member schools from legal challenges that hinder their ability to govern college sports. The Protect the Ball Act, as it's called, aims to provide a legal safe harbor for the entities that run college sport, which have been under scrutiny from antitrust laws. The bill will allow the NCAA to regulate recruiting, eligibility standards, and the way college athletes are compensated for name, image, and likeness. The lawsuit settlement being considered would create a revenue sharing system for college athletes, but the NCAA and conferences will still need federal help to shield them from future lawsuits and potentially create a special status for college athletes.
Thank you, Ed. So that about wraps up our NCAA name, image, and likeness, or NIL updates. Thanks for joining us today to discuss this topic on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.